You may.
May it please the court, my name is Bob Swain. I'm here on behalf of Alachua County. I would like to reserve 5 minutes for rebuttal.
You may.
We are here on an appeal of a declaration of rights order from the Circuit Court in Alachua County. The basis of that was a budgetary issue between the sheriff and Alachua County over whether or not the sheriff under Chapter 30, 49, and 12602 was required to come back to the Board of County Commissioners to seek approval when moving money between budgetary objects as established by the legislature in 3049 and through the Unified Accounting Systems Manual.
So was the sheriff trying to move money from object codes from functional category to functional category?
At the time of the summary judgment, we did not have any evidence of that, and that was, the court ruled against us. The net effect of the court's order, though, would mean that the county would not have the ability to require that, or the sheriff would not have to come back for that, because the court viewed the sheriff's
Between
budget-
functions?
Between functions, yes.
Okay, so just so we got our terms right, the 30.49 has basically 3 functions.
Yes, sir.
That the budget has to be allocated in. That's general law enforcement, corrections and detention, and court services. And below that, there are 6 categories of objects, and with each function, there would be an object, each of these objects in there, correct?
Correct.
Okay.
And then within each object, there would be numerous sub-objects.
Yeah,
They're broken.
individual expenditures
Right.
within the
Well,
objects.
it's actually broken down into additional, for lack of a better term, categories.
Okay.
And then from those individual categories under the sub-objects, you get the line items for positions, for specific expenditures and such.
So for instance, under personnel services, there would be salaries and OPS and any
Exactly.
other contract employees kind of thing.
Exactly.
Okay.
Everything to do with personnel services, FICA, benefits, what have you.
So what was the sheriff doing here that brings you to court? See, the sheriff was moving money from object codes within one function, right?
Yes, that was, the evidence that the court was presented with was that the sheriff was moving money between object codes within one
Were
function.
there any allegations in the amended complaint regarding the sheriff transferring monies
Within
each
the
function?
objects codes?
Yes.
Well, the matter was at least tried by consent.
If there are no allegations in the amended complaint to that effect, why does the amended complaint state a case of controversy for purposes of a declaratory judgment?
There were allegations in the amended complaint that money was being moved between objects. Transfers were being made, and that's what a transfer is. At the time, it was before discovery, and it was bare allegations based upon computations. As discovery went on, the discovery from Patricia Justice was that they had in fact moved money as necessary on a day-to-day basis sometimes, but in the example that was given was to buy ballistic helmets.
So in reading the briefs, it seemed like both sides had very good policy arguments for their position. The commission, their policy argument was that they're in charge of the public fisc and allocating monies, and they have to be able to put money in a particular category and know it's going there and not to some other reason, which is a good policy reason. The sheriff, on the other hand, had a policy argument that that I'm the sheriff, I'm responsible for law enforcement in the county, and I should have a high degree of autonomy in doing that because the commission doesn't know where I should put a deputy or those kinds of things. But I'm looking for, what's your best statutory basis for your position? Because, some of these statutes can go either way, but I want to hear your best statutory case for why the sheriff shouldn't be allowed to do this.
The best statutory case is 3049-8 that says that the sheriff will follow county budgetary procedures. 3054 that says she will follow the procedure set forth in 129.062. 129.062 provides for the county budget, the ability to transfer within a fund whenever the full, the gross dollar appropriation does not change. So that would be at the functional category, that would be at the object category, those changes. So we have to keep in mind the backdrop that the sheriff has authority within the objects over the sub-objects. So she has absolute autonomy over how much she pays her deputies, how many deputies she has within her budget. And that's a budget that she prepared herself, and if she didn't like that budget, she, you know, as funded by the board, she could have appealed it.
So what about 12903 sub 5? It says, any constitutional officer whose budget is approved by the Board of County Commissioners who has not been reelected to office, you know, a lot of qualifiers. Basically, it says that they can't transfer funds between itemized appropriations if they're basically on their way out and they're a lame duck.
Yes, sir.
So doesn't that kind of leave the impression that otherwise they can transfer those funds without permission of the county commission?
Well, one, to read it that way would mean that any sheriff would have the full authority of her budget to move anywhere she wants. This sheriff would have over $70 million to spend as she wants to spend it. A sheriff in Broward County, bigger county, would have almost $1 billion to spend any way he wants it without any oversight. Despite the fact that...
Well, sheriffs are elected. They're subject to ultimate oversight by the people, correct?
Every 4 years by vote, yes.
Yeah.
But in the meantime, that's a lot of money that they've had oversight to, and the legislature has set this process up. Now, I would suggest that that portion of the statute, 129.065, should be read exactly for what it is, just applying to lame ducks. And that those...
Yeah, but it purports to take away authority from lame ducks, so that seems to indicate that otherwise the sheriff had authority to do this. If there's a statutory provision that says a lame duck sheriff may not do X, I think it's a reasonable supposition that otherwise a sheriff does have the authority to do X.
If it's read that way, it ignores the fact that 3049.8 and 3054 require the sheriff to go through 126.02. It doesn't say just lame ducks. It
What's
says,
the context here? What was the sheriff doing that facilitated this action?
in this particular case,
In plain terms.
in plain terms, there was an event where there was a budgetary issue between the sheriff and the board. There had been an appeal in a previous year, and the board was wanted to fund vehicles. There was a need for vehicles. The sheriff, in her judgment, wanted to give her people raises. The board funded vehicles, which would have been in a different object code. The sheriff took part of that money in a different object code and used it to fund raises. She also bought vehicles with the remaining, but she made that unilateral choice.
Well, that's very helpful. I mean, I think that puts it in context that, your view of that is that it's illegal to do that. So how much did she take out of the budget for cars that your client appropriated and used for raises?
Well,
I know legally, in your view, it's, whether it's $1 or $1 million doesn't matter, but I'm just curious.
My recollection is that the allocation was in the neighborhood of $500,000 for vehicles, and she used somewhere around $200,000 for raises.
Were these allegations of fact set forth in your amended complaint?
No, they were not.
Well, the facts here are not really in dispute, are they? I mean...
I don't believe the facts are in dispute. I think the issue is pretty much a question of law.
Right. So your opposing counsel is not likely to stand up and say, no, we didn't use $200,000 for raises.
She may contest a specific amount, but the fact that the money was
Used for raises instead of cars.
Right. And the sheriff had told the board she was going to do that. There was no doubt what was going to happen before that vote was taken by the board.
You say last year there was an appeal to the Board of Administration, the Cabinet?
2016.
There was an appeal to
There
the
was an
Cabinet?
appeal, yes. And basically, the view of the the county commission was that we need to find out whether we have any budgetary oversight, authority, and responsibility regarding the sheriff. Or whether we just give her a bucket of money and she spends it as she wishes.
So it appears that the issue is the independent authority the sheriff has over county funds that have already been allocated to her, is that correct?
Appropriated, yes, sir.
Okay. Didn't the Supreme Court decide a similar issue in Weisenfeld?
If I may, yes, sir. Weisenfeld is one, supports this because Weisenfeld, if you look at those specific categories, those are what we now call the object categories.
Well, the trial court relied on Weisenfeld in support of its decision, didn't it?
It did, but what the legislation at the time, and keeping in mind that the sheriff and the county commissioner are constitutional officers with limited authority granted by the legislature.
So Weisenfeld contains the following sentence. This court finds that the county lacks the authority to require a sheriff to seek county's approval prior to making transfers between object codes.
It says within object codes, Your Honor.
Prior to making transfers between object codes.
Are you reading from the case?
Yes, I am. Oh, actually, I'm reading for the order. Let me find the case here.
So while you're looking for that particular sentence, your view then is, look, Sheriff, if you're dissatisfied with $500,000 for vehicles and how much was appropriated for salary, approximately? The different object code.
The salaries would total in the millions.
Okay.
Okay.
So your view is if you're dissatisfied with the money for salaries, your remedy is to appeal to the governor and cabinet, right?
Yes, sir.
Okay, Weisenfeld has the following language. We find the internal operation of the sheriff's office and the allocation of appropriate monies within the 6 items of the budget is a function which belongs uniquely to the sheriff as the chief law enforcement officer of the county.
Correct, within each of the, doesn't say between, it says within.
Yes, but there's no allegation that there was money transferred between functions. It was just objects within the function.
These, at the time, functions did not exist. These are objects now. The legislation.
So if the sheriff wins this appeal, if we rule in the sheriff's favor, then your view is that, let's say a sheriff has $1 billion budget and you're not arguing she shifted money between functions, but object codes. So let's say the function is corrections. Then if the sheriff prevails, your view is any sheriff can move money in the corrections function from cars to salaries to food for the jail to whatever object codes there are.
Yes, sir.
And your argument is that makes the sheriff the appropriator.
Essentially, yes, because she's taking fixed appropriations and moving them around.
I'm going to give you 3 more minutes on both sides for your argument. So you'll have more time on rebuttal. You may continue your argument if you wish, but I'm allocating 3 additional minutes per party. Thank you, Madam
May I
Clerk.
ask one question for you?
Sure. No, he can, go ahead. He has more time now.
For purpose of this appeal, is it your position that Weisenfeld supports the county's position on appeal in this case, or is it your position that Weisenfeld is obsolete?
My position is Weisenfeld's obsolete because of legislative changes, but they also put the Weisenfeld decision into context, because now we have Weisenfeld is now clearly at the object code level, and so Weisenfeld can be read, if the court doesn't find it's obsolete, it can be read in support because the money was not being shifted between object codes, it was being spent in object codes. The other thing about Weisenfeld was procedurally, that was after a budget appeal. The budget appeal came back partially in the sheriff's favor, and the Board of County Commissioners still sequestered the money. So that, I think, is a big factual distinction. But sadly, there's not enough of a factual basis. The helicopter program mentioned in there was being funded from two different objects, but that could have been personnel in one and equipment in another. So there wasn't necessarily a shifting between them, but the complementary use of the two object codes. And I'll reserve the rest of my time for rebuttal.
May it please the court, my name is Cynthia Wygant.
And you can pull that microphone down.
I have the honor of representing Sheriff Sadie Darnell. And I'm assuming that we're not going to talk about the order dismissing count 2 or the summary judgment order, so I'll just get right into the order denying declaratory judgment. And you're right, this is a case of statutory interpretation. I think we've all agreed on the facts. The sheriff is an elected constitutional officer, as is each member of the Board of County Commissioners, but it's the sheriff who is elected as the chief law enforcement officer of the county and has the responsibility for determining
So 30.49 requires the budget to be set out between functions, the three functions that I talked about before, and within each function, there's 6 objects within there, okay? So why would the statute require the sheriff to submit a proposed budget that went down to the object level, and the county commission approve that and appropriate that money down to the object level, if in the end the sheriff could just spend the money however she wanted to?
And that's all for the purpose of complying with the Uniform Accounting System Manual and the Uniform Chart of Accounts. If you look at 218.33, every local governmental entity is required to comply with that Uniform Chart of Accounts, so it's just a method of organization. Budget is about projecting what you're going to need, and then the legislature has decided that every local governmental entity just organize its budget this way, that you've got every local governmental entity has different types of functions. The functions for the sheriff's office are set out in 30.49, and then you've got all those object codes. The county's going to have different types of functions. So for the purpose of uniformity, so that everybody speaks the same language. In the end, every local governmental entity here in Alachua County will submit a financial report to the county. The county, as the reporting entity, then takes all those annual financial reports and sends a total financial report to the Department of Financial Services.
To what extent should we analogize to state-level budgeting? Or is county budgeting different than state budgeting? Because I know in state budgeting, you know, the judicial branch is required to submit a proposed budget that's approved by the legislature. And you know, there is some flexibility within objects to move money, but if we want to move money between objects, we have to go ask for permission.
Well, for purposes of organizing the budget, I think the only difference between the state and county is the fiscal year. But for purposes of the sheriff and the county, again, the sheriff is an independent constitutional officer. I think the lesson that we should take...
Well, I would argue that the Chief Justice is also.
I think the lesson that we should take from Weizenfeld is that, you know, overall, the lesson that the Florida Supreme Court has is that the sheriff is the one who is elected to oversee the budget that she is appropriated. She's the one elected by the people to make those funding decisions, how she should meet the law enforcement operational needs for the county. And under 30.53, she is given that independence. She retains that independence that she had as a fee officer prior to 1957. As fee officers, they had the right to hire fire personnel, select what to pay their personnel, determine what supplies and equipment they needed to operate their office, and purchase those supplies and equipment. And they did that all independent of the county. So when the legislature moved away from the fee system and went to a budget process, they included within that statutory scheme a specific preservation, and that's in 30.53. Now, the county insists that the 30.49 and 30.50 and 129.06 all require that the sheriff adhere to the county budget process. The statutes don't say that. If all the statutes say is that it requires the Board of County Commissioners to include the sheriff's budget within the county's overall budget. There's nothing in 30.49 or 30.50 that specifically tells the sheriff, you have to seek approval if you want to make transfers between object codes. And when you think about it, it's kind of ridiculous. So for example, I want to give you an example of why we would need to make a transfer. You know, keep in mind, the budget is put together in March and April for a submission date by May 1st. Say in April, you know, the sheriff determines that she wants to buy 10 radios in the new fiscal year, and she's gotten a price of $950. So the money that's going to be used to purchase those radios is placed in the operating expenses category. Well, 6 months later, now those radios cost $1,005 each. Since everything that costs $1,000 or more has to come out of capital outlay and it has to be kept in an inventory, we have to take that money from operating expenses and move it to capital outlay. And under the county's viewpoint, we would have to ask them for permission to do that. And that totally interferes with the sheriff's independence, and it intrudes upon her constitutional right to be independent of the county in maintaining her budget.
So is there any limit on the sheriff's ability to transfer money between these objects? Because, you know, it seems like we go through this exercise to say, you know, this is what I think I'm gonna need, and the commission looks at it and blesses that.
Mm-hmm.
And if it doesn't mean anything, first of all, why do we do it? And then is there a limit? Can the sheriff say, I'm gonna spend it on these things and then totally do something else with it?
I would say there is meaning, and for the most part, you know, the sheriff fully intends that this is how we intend to spend this money. You know, but things happen, things change, needs change, and at some point, there may need to be monies moved.
So in your view, and I appreciate the historical background, that's very helpful about the prior methods, and I know in the late 50s, the legislature provided the appeal process for a sheriff, which I've actually participated in a prior lifetime. So your view is that, I guess, what's the function we're discussing here between the two objects of cars and salaries? I guess
This is in the law enforcement function, and I'm glad you brought that up. So just to add a little bit of factual background, a little more finite detail. The sheriff had asked for raises. The county had granted raises to all of its departments and all the constitutionals, and it also funded raises for the other functions of the sheriff's office. So the jail got raises, court security got raises. The law enforcement function, however, they did not fund those raises. So that's why the sheriff, when she came back and asked for more money for vehicles, because she did not get as much money for vehicles as she had asked for also. So she asked for the money that she was returning at the end of the year, for some of that to be appropriated back. She fully intended to use some of that money for vehicles, and she did, and she also said she wanted to use some of that money to fund the raises that were not funded in that function.
right, but, and I'm just trying to get this factually straight. So in the law enforcement function, there's approximately $500,000 for vehicles, millions of dollars for salaries in the object code. And I can tell you, at the state level, for example, a lot of state workers didn't get a raise. Some did. The legislature picked who gets a raise, and they did not give a raise to other state workers. So, in fact, there hadn't been an across-the-board raise for state workers in quite some time. So the Alachua County Commission, the legislature for the county, said, here's how much we're giving for salaries, and we'll give you $500,000 for cars. Under your argument, because of the constitutional nature of the office, the sheriff can take money from cars and say, you know what, the legislative body should have given you men and women in law enforcement a raise, and they didn't, so I'm going to give you a raise. That's the argument?
Yes, yes, because.
Because I can tell you that argument would not fly in Tallahassee at the state level.
I can,
I can tell you
I'm sure
that.
it wouldn't.
No, it would
But
not.
again, you know, the sheriff has the inherent authority within her budget to be able to move those monies as operational needs change, and as she determines how she needs to allocate those monies.
Because as my colleague noted, I can assure you, the Chief Justice doesn't have that authority. The governor doesn't have that authority to move money from object codes and say, you know, I mean, there's certain flexibility, and there may be some analogies there that, to be fair, you could cite to if we had more time. But, I mean, that's a pretty stark, profound argument that the legislative body gave me X for cars, gave me Y for salaries. I don't think they made a wise decision, so I'm going to move money from cars to salaries.
And if the taxpayers don't agree with her decision to do that, they're free to vote her out of office at the next election. Because, and you touched on this, Judge Roberts, about 129 or .06 subsection 5, that is the only clear language that puts any kind of limitation on the sheriff as a constitutional officer's authority to do those things within her budget. As opposed to 30.494, where the county clearly has the authority when they take the sheriff's proposed budget. They have to look at it. They can alter it, they can modify it, they can increase it, they can reduce items, but once they appropriate that budget belongs to the sheriff, and the only limitation on her abilities to move funds as she deems necessary is in 129.065, and that's when she's chosen not to run for office and hasn't been reelected. That's the clear language here. So
How do you read then the provisions regarding the sheriff's budget appeal?
that applies whenever,
Well, my question being this, I'm sorry to interrupt. So isn't the sheriff's remedy if the legislature, the county commission says, we're only going to give you X for cars and we're only going to give you Y for salaries for a total in the law enforcement function of Z, the sheriff says, that's not enough for my personnel for salaries, and the Alachua County Commission says, yes, it is, in our view. Isn't the sheriff's remedy at that point to appeal to the governor and cabinet and say, they shorted me on salaries, they shorted my law enforcement function, I need another $1 million in the law enforcement function, i.e. I need another $1 million in my budget?
that is an option. However, it's within the sheriff's appropriated budget. It is far simpler for her to move monies.
Oh, I know it's simpler.
Filing
I know it's easier to move money between object codes without doing a budget amendment or
Sure.
filing a sheriff's budget appeal.
And then she just has to do without the vehicles that she could have purchased had she kept those monies within capital outlay.
How often
Filing-
does the county commission meet?
I'm sorry?
How often does the county commission meet?
They have proper meetings rather every 2 weeks.
So if a situation came up where the sheriff needed salary money, or to take it out of something that they're already in dispute, but the sheriff needed to buy, ballistic helmets, arguably you could notice it and get it heard by the commission within 2 weeks.
If we had to, if that was the
Okay.
court's ruling. On the other hand, if something immediate came up, we would not be able to have the time to wait those 2 weeks. And I know the county's counter argument to that is going to be, but we've designated our county manager to have authority to approve of transfers for up to $50,000. But the sheriff's viewpoint is the statutes don't require her to do that, so why should she?
So what's your best statutory argument? Judge Roberts asked that of your opposing counsel. Why don't you give us your best statutory argument?
There's two, there's the 30.53 and the 129.065. 30.53 sets out the independence of the sheriff in hiring, firing, selecting personnel, and purchasing supplies and equipment. The county's counter argument to that is that, well, those are just object codes. But again, they've placed an artificial limitation on what the Uniform Chart of Accounts requires and what the Uniform Accounting Standards Manual requires. That just requires how you codify your expenditures. It is not a limitation on what the sheriff spends her monies on. They just want to make sure that she's properly recorded how she spends that money. Under 129.065, it's clear that the only limitation on the sheriff's ability to transfer funds, make amendments, or spend more than 1/12 of her budget is under those limited circumstances when she's a lame duck.
Can one equate the act of transferring already appropriate funds between objects with amending the total budget?
I'm sorry?
Can one equate the act of transferring already appropriate funds between objects with amending the total budgets?
That's an interesting question. I regard the amendment language as allowing the sheriff to pretty much do anything. So at trial, both witnesses were asked, well, how do you define a fund and what's an amendment? The sheriff's witness defined an amendment as when a total amount of a fund changes. So within the sheriff's office, we have our general fund, and that's what's used to fund all the sheriff's operating expenses of the office. We maintain a few special revenue funds, and that's primarily for grants. So if the sheriff, if an amendment has to do with the bottom line of the fund, that's not something we would do because those special revenue funds are limited. I do read that language as very broad and allowing the sheriff to transfer between functions if she needs to, as well as between object codes. I believe that the trial court's order struck the proper balance between the county's duty and responsibility to oversee and to review the sheriff's proposed budget and to make those determinations and then appropriate a budget. And
I
the
understand the
sheriff's,
county's argument with regards to the Supreme Court's Weisenfeld opinion, that Weisenfeld supports the county's position, but if it doesn't, then the subsequent statutory changes have rendered Weisenfeld obsolete.
I think it's an improper argument. Again,
Why?
if the legislature has chosen to require local governmental units to organize their budget and expenditures at a different level of detail, that still does not provide any spending limitations. It's just a different means of reporting receipts, if you're a governmental entity that gets receipts, which the sheriff is not, and expenditures. It's just a higher level of detail, that's all. It's not a limit. It doesn't say anything about what the sheriff, how the sheriff spends her money or what she can do with her budget. It doesn't have anything to do with budget per se. So I would ask that the court affirm all three orders under appeal. Thank you.
Thank you.
May it please the court. I'd just like to address several points. To begin with, despite the referral to the uniform accounting manual as being just a way to track expenses, 3049 by statute sets out specific categories the sheriff has to budget by. She is the only constitutional officer that has those requirements. There are references to the uniform accounting manual, which is developed by the Department of Revenue, administratively, not adopted by the
So
legislature.
the other constitutionals don't have to break it out this way?
Not that way, no.
Okay.
They may have to do it by object codes, but generally, if you're a local government entity that reports, you have to report according to the accounting manual.
Okay.
But
So you're arguing that, in fact, that the county commission has more authority over the sheriff than they do over the other constitutionals?
what I'm saying is that the legislature intended the language they meant. And the county commission has different authority over the various constitutionals. For the supervisor of election, the county commissioner has pretty much full authority, other than they can't tell her where to buy her stuff. Pretty much the same language as 3053. The clerk, only half the budget is county budget, half is state. Tax collector and property appraiser both are entwined with the Department of Revenue, so it's a different situation. As far as the amendment goes, both references to the county budget in 3049 and 3050 talk about amending the budget. Since 12602 was created by the legislature, we have to presume they knew what amending the budget was, and that includes, in their view, moving money around in the budget that does not increase or decrease the total amount of the fund. So, in fact, it is contemplated that amendments will go through the county process and not increase the total amount of the fund. Also, a strict reading of 129.065 requires that whoever is not reelected has to get approval. That would set up two classes of sheriffs, those newly elected, newly appointed, and have not yet qualified for re-election and are unopposed, and those who have been re-elected. So for the first 4 years of a new sheriff's term, or for first 3 years and change, that sheriff would have to go to the board for everything. It's an absurd result. We would request that the court reverse.
Thank you. Thank you both for your arguments. We'll be in a short recess while we reconstitute the panel. Thank you.
All rise.